visa bulletin, what's expected, how the priority dates are expected to move. We're going to discuss about if you file can you file an adjustment of status with a company that you're not working with, for which you have an I-140 approval. So if you previously have worked with the company, or you filed it as a potential employer without working for the company, can you file a 485 application? The third main topic that we're going to cover is that once you get an GCEAD, do you still need to maintain the H-1B, or you can get rid of the H-1B? Now, Rebecca Chen is with me today. Rebecca, where do you expect an August visa bulletin? It's about to come maybe this Friday.
Yeah, so there is a lot of speculation about this next visa bulletin, which we're expecting in the next week or so. Of course, we don't have any prior knowledge of any exact dates, but based on the trend of the movement of the dates in the past months this year, what we see is that there has been, the forward movement, the increase in the number of months that are added in EB2 and EB3 has been going up since, just May this year. The movement of the EB2 dates, for example, has gone up by 3 months, then 4 months, 6 months, and then for EB3, from May until July's visa bulletin, which is the one we're currently in, the date movement has gone up from 5 months, and then in the next month it moved up 9 months, and from June to July it moved up 14 months. So that is the trend that we've been seeing. We also know from previous fiscal years that it's always that in the summer, this is the end of the fiscal year. We know the government is, the State Department at least, is trying to get through the applications that have been filed earlier this year, and so they are, the State Department at least seems to want to move the dates up more. I don't know, Rahul, do you have any predictions of months?
So let's look into the EB3. The way you spoke is that from April to May it was 5 months, from May to June it was 9 months, movement was, from June to July it was 14 months. So it's 5 months, 9 months, 14 months. Do the math. That should be 17 months, or maybe 18 months. So approximately from January of 2013 to, I'm expecting maybe somewhere in January of 2014, or maybe even May of 2014, somewhere around that period, I'm expecting the EB3 to go up. When it comes to the EB2, the final action dates, since from April to May it was 3 months, from May to June it was 4 months, from June to July it was 6 months. So if I were to go along accordingly though, I'm expecting that it may touch December of 2011, or even further for the EB2 though. Final action dates for August month. That's the expected thing. Now, how is that, Rebecca, that the State Department is now telling they're going to waste all the green cards, yet they are not making everything current? Explain the logic. Isn't it the duty of the USCIS? Isn't it the duty of the State Department to give the green cards to the individuals who have filed or eligible for? Instead, they initially said they may use most of the green cards. Now they are telling that, oh, a good number of green cards will be wasted. What do you see? What do you say about that?
Well, yeah, that's the tension, I guess, between the State Department and USCIS. They're different agencies, separate departments of the federal government, and the visa bulletin is published by the State Department. The priority date movement is determined by the State Department. But USCIS is the one that is responsible for processing and approving all the I-485 applications that are filed based on the priority date movement. So we have seen, not just this year, but in previous years also, kind of tension between the State Department and USCIS. The State Department wanting USCIS to adjudicate more of these applications so that there isn't the wastage of the green cards in order for immigrant visa number to be considered used in a fiscal year, the green card actually has to be issued. It's not enough for the I-485 just to be filed. And so based on the kind of recent statements from Mr. Oppenheim at the State Department, his recent comment that there may be wastage of the green cards, that's due to his observation or prediction that USCIS may not be able to adjudicate all the I-485 applications that they have received so far this fiscal year, which is why in recent weeks we have been encouraging everyone to contact their representatives, congressmen, to put pressure on USCIS in order to try to prevent that and get those visa numbers used in the remainder of this fiscal year. What do you think, Rahul?
Here's the thing. Last year, the first 2 quarters, Rebecca, they accepted around 70,000 485 applications. This year, they have accepted around 210,000 485 applications. So they did definitely accepted 140,000 extra applications than compared to last year. That doesn't mean that these people are going to get the green cards, though. So that's the reason we have drafted a letter for you guys to contact the congressman. Because if you guys don't contact the congressman, you're going to increase the wait period by about 26 years, because approximately 270,000 green cards will be wasted if you don't do the action. So if you're in the 485, so you need to write a letter. We have given the draft at the bottom of this one. So as an office policy, that we don't want to take your calls, we don't want to take your emails, we don't want to answer you for free unless either you write letter to the congressman or you promise that you have written letter to the congressman. When you're putting a question to us, I want you to put these things, put 3. That means that you have done 3 activities. Written a letter to the congressman, send a copy of that letter to the Joey Lufgren, who is a good congresswoman, and send an email to the state visa department asking the question, why are they not making all the dates current? They did that in 2007. Every date, it's not moment. All the dates were been current because the USCIS did not act on it. So if you have done those 3 activities, when you put a question, put that you put 3. If you have not done it, you're promising that you're going to do it, then put 3P. In that way, that we will give preference to the people who have been active, who are writing letters to the congressman. And we don't want those people who believe in discrimination now, discrimination previously, and discrimination forever. We don't like them. So we like the people who want to use these green cards. There are a lot of pending bills. But if USCIS and State Department act, a lot of things can be done without going to the parliament. So it is your promise, it is your activity that's going to make it. Now, even if you did not file the 485 application, though, this is going to be beneficial for you, because if you're waiting for the green card, if the people who have filed before get the green card, it'll be clear for you, your green card chance will come much faster. So when you ask question, put it out 3 or 3P. We know that either you have written the letter or you promise that you're going to write a letter. That's when we will be able to answer your question. Now, Rebecca, have you filed any adjustment of status for the people who have not been working for the company?
Yes, we have in the past, and there's nothing technically wrong with that. So the I-140 petition, an employment-based green card application, it's always based on a future offer of employment. So the I-140 position is technically a future position that you would fill with that company once you get the green card, the future permanent position. So there's no actual requirement that you be in that job currently, that you be working for the I-140 petitioner currently. Of course, if you are, that is, a pretty strong confirmation of your intention to work with that company and fill that position if you're already in that role or with that company, but it is not technically required. So you could have an I-140 petitioner file a petition for you, a downgrade for you, even if you're not currently working for them, but the job offer needs to be there. That petitioner, that company needs to be willing to certify to the government that they have this position and are offering you that role.
Especially we're expecting the priority dates to move in October of 2021. So if you don't have a perm labor and I-140 approval with your existing company, or at least perm labor with your current company, it may take a long time for you to get this perm labor. You may want to contemplate going back to your old employer, or going back to the old employer requesting him to file 485 if the job offer is still open. We have seen that many times. The companies have done it, have filed it. We never had any issues with those things. It goes on through smoothly. It's not a rocket science to file a 485 application for if you're not working for the company. It's so easy. If they file a 485J supplement, that's easier. And if they have to downgrade, they can file an I-140 and 485. You can contact your ex-employer or any employer who has an I-140 approval. People also ask question, hey, my ex-employer has withdrawn my I-140 application. Can I still go back and have them file a 485 application? There's one condition, that if they are willing to file an I-140 again for you, even though they have withdrawn the application before, you can get the previous old priority date, assuming that that I-140 has been approved, and you can get the old priority date and you can file the 485 application along with the I-140 application, even though they have withdrawn the application. Rebecca, when people are getting the GCEADs, do they need to maintain the H-1B? Is it mandatory to maintain the H-1Bs?
It's not mandatory. There are a couple of kind of limited situations where we would definitely recommend it, mostly based on kind of a family situation. If you have children who are not U.S. citizens who filed the I-485 application concurrently with you, and they are nearing the age of 21, at which point they would age out and no longer be eligible for the green card. If you have children in that situation who have a pending I-485, we do recommend that you maintain your non-immigrant status, whether H or L, for the sake of your children being able to stay on H4 or L2 status until they can switch over to F1 if that becomes necessary, if they're close to aging out. Another kind of limited circumstance is if your spouse or other children are not in the U.S. right now, if they are stuck in India waiting for a visa appointment, and they have not filed the I-485 yet, but will be able to when they come here, you need to stay in H1 or L1 status so that they can get that visa from the consulate, come to the U.S. and file for adjustment of status here. Outside of those limited situations, Rahul, do you think it is what do you think about maintaining H-1B status after getting the EAD?
Outside the situations, what you said, the only reason I would maintain the H-1B is to make an immigration lawyer rich.
Okay.
There are some people who just live only to make immigration lawyer rich. If your purpose is that, definitely go ahead, do it. There are a lot of minus points in maintaining the H-1Bs. You do get denials of the extension, denials of the amendments, and your H-4 EAD sometimes get a longer period of time. It doesn't get approved. Every time you go outside the country, you have to get the stamping to maintain the H-1B. These are all the complications that comes with it. Plus, your company will be shelling a lot of money to the immigration lawyer. I personally would not like to maintain the H-1B if I get my EAD approved. Vikas Chauhan has promised that he's going to write letters to the congressmen and question the visa department why they're not making the dates current. Thank you, Vikas. And he put 3P. That means that we're going to answer those questions with 3P and 3. Because if you have previously approved priority date of May 2015, your question is, should you go in EB3 premium immediately, or should I wait for September visa bulletin? Since it's May 2015, because I'm going to file I-140 in premium processing, get it out of my way. We choose, seems that Emily, me, and Rebecca, we're on the same page on whether you should choose EB3 or EB2. Seems to be we are. choosing EB3. We may go wrong on it, but anyway, if by any chance EB2 advances though, you can always file an EB2 application again too. You can choose to file EB2 and EB3, both of them at the same time in premium processing. Second, because your labor certification is still valid, you're within the 6 months period, you can still do it. You can do it. I personally will do only EB3 under premium processing. That's my choice, but it's up to you. Venkat has this question that what is the AILA involvement in stopping the family-based to employment-based? You stop acting, you're bad, and whatever not. We do hear these things a lot. We are proud members of AILA. Absolutely, we are all proud members of AILA. We have membership on a lot of different things, guys. Doesn't mean that if a particular organization is doing all activities, we are not supporting each and every activity the organization does. In this particular incident of stopping the family-based to the employment-based, we disagree with AILA. That doesn't mean that AILA is bad or we are villains, they are villains. They have their own reasons. They support the family-based immigration, nothing wrong. That is their stance. That is how they do. Doesn't mean that just because we believe in the employment-based, we're going to bash with AILA and we are going to resign from AILA. I've been a proud member of AILA from 1995. One of the first 10,000 members of the AILA. They reward me every time I go, oh, you're the very old member of AILA. We're very proud. Yeah, of course, we disagree with them time and time again. Sometimes we disagree with them. Within our own office, we have lawyers, partners belonging to different political parties. And these political parties sometimes take different stance. Some people, so I'm a proud Democrat Party person, and then there are Democrat parties that try to only look into the asylum cases more and certain other things. That doesn't mean that I support everything Democratic Party does. So just because we belong to a membership doesn't mean that we support each and every of thing what our organization or what the organization we belong to does.
So Nikki from YouTube is asking about actually switching from using the I-485 EAD to an H-1B visa. So hopefully, as we discussed earlier, that may not be necessary, Nikki, if you don't have family in a certain situation that would require you to be on an H-1B visa. You should be able to continue on the EAD, but if there is some situation that does require you to get back into non-immigrant status, unfortunately there isn't really a way to do that while remaining in the U.S. You can't file a change of status from being an adjustment of status applicant back to H-1B. It does require having to go to the consulate to get a visa stamp and coming back in to the U.S. in order to reactivate or get back into H-1B status.
Ram has written letters to the congressmen of his constituency and has sent a copy to the Joe Lufkin and has questioned the visa department, why can't they make all the dates current and certain other questions. That's very good, Ram. And he's asking the question, does the dependents in the green card applications are counted as single or they are counted with the actual numbers? Unfortunately, Ram, they are being counted as an actual numbers. So for example, Ram, if you are married and you have a child born outside this country, so they will take up 3 numbers, not 1 number. So that's unfortunately the case. When it comes to the H-1B, only the main applicants take the H-4s don't take it, but when it comes to the 485 dependents, they do take the numbers, unfortunately. Karthik loves music from YouTube as his question. His I-140 has been approved with the previous employer. He's filing a 485. Does he need to fill an A number on the 693 medical form? I would recommend that you do not fill the A number at this point of time. They normally put out with the old employer because they'll give a new A number. I would recommend that you don't do it, but if by any chance it's already been done, it's not a big deal if you put but typically I do not recommend that you fill the 693 with the A number.
Yamini is asking about his premium upgrade being rejected by USCIS for his I-140 downgrade petition, sent back stating that the original ETA 9089 must be present in order to upgrade it. So don't worry about that at all. That is normal. The fact that the I-907 and the check were sent back does not mean that the I-140 is being denied or is at risk. The I-140 should continue to process. The Service Center is just sending back the I-907 form and the premium processing filing fee check because it is taking them longer to pull the original labor certification from your first EB2 I-140 file. So most downgrades, because they are filed based on a perm application from several years ago, one that was already mailed into USCIS with your EB2 I-140 petition, USCIS, when they get the new EB3 I-140 that was just recently filed in the past year, they need to go back into their files to find your EB2 I-140, pull your original labor certification that was probably printed on that purple paper back then, pull it from that file, put it with your EB3 file before they can upgrade your case to premium. Because without doing that, they can't process the case. They can't guarantee that it will be done within 15 days, and that's why they're sending back the I-907 to you. But don't worry, that has been pretty common. Just wait a few weeks and then send it in again. Just try again. We have tried 3 or 4 times sometimes to upgrade I-140 downgrades in our office. Eventually it will be successful once they have matched up the file.
Was from YouTube he promised that he is going to send letters to the Congress people, and he's going to write email to the state visa based on the drafts that we have provided. His question is, his wife came in United States in 2019. Her H4 plus EAD is expiring in February of 2022. She moved on to the H1B. Now, how should she move back to the H4? His previous company, H1B has been revoked. I'm assuming that he's working for a different H1B, different company on H1B. There are 2 ways that you can do was for her to get the H4 and EAD back. Number 1, you can file H4 plus EAD, change of status from H1, while in United States. It's going to take around 11 months to about 20 months to get the H4 plus EAD. And by the way, the H4 is and while the H4 plus EAD is in the process, though, she cannot work. There's another easy thing that I call it as automatic revalidation. Instead of spending money on people like us and waiting for 11 months, she can do one thing. You and your wife can go to Mexico, have a margarita, and I forgot it, one more, and a tequila. And you come back into United States. You may ask me the question that, oh, your H1B is not stamped in the passport. That's okay if the H1B is not stamped in the passport. You can still go out if you go to Mexico or Canada. It's called automatic revalidation. You can come back. When she comes back, she says that she's married to you and she's coming on H4, and she can show the H4 stamping, which she already has it. She can come in and then she can start using EAD. Once she comes back, you can file the H1 and H4 and EAD extension, so that in the interim period, while this H4 plus EAD extension is pending, she can continue working until February, because that's when her EAD is expiring according to your statement. So she can work by going to Mexico and coming back. She can change instead of going through the process and then waiting.
Sai Kiran filed an EB1C I140 petition, it looks like in April 2021, and is asking whether he should file the I-485 concurrently with it. It sounds like he's been warned that to maybe not file the I-485 concurrently, because if there's a denial, it could cost a lot in the fees. So that is true. However, it kind of depends on what you think the chances are of approval on the EB1C I-140. Even in the worst case scenario, if it does get approved, if it does get denied, I'm sorry, the I-485 application, if it's filed concurrently or based on the pending I-140, it would be denied automatically if the I-140 is denied. However, it doesn't prevent you from filing again later. So the worst case scenario is you would lose the filing fees and potentially legal fees associated with filing the I-485 application. What you need to keep in mind is the EB1C I-140, unfortunately, is one of the only I-140 categories that does not have a premium processing option. So if it was filed in April of this year, it could still be pending in spring next year. It takes a very long time for EB1C I-140s to be processed, especially if there is an RFE. And you can only file the I-485 while the EB1 priority date is current for India. I'm presuming that your country of birth is India. While we are not expecting retrogression in the near future at all, we don't know what the situation will be like, in spring or summer of next year. It wouldn't hurt to file the I-485 just to get it submitted and pending, as long as you are aware that there is the potential of losing the fees.
Mayank Singh has promised that he's going to write letters to the congressmen and the email to the State Department. If the employee becomes 100% remote, does the POM need to be refiled entirely and start the process from the scratch and retain the priority date? Mayank, there are two kinds of company. One is a consulting company. Normally, consulting companies put a documentation saying that you could be working in unanticipated location. If that's there, you are covered, absolutely no problem. If you're working for a direct company, not a consulting company though, even though you're working remotely, your location has changed right now. If the position is still open, let's say for example, the job is in California. Now you're remotely working from Dallas, Texas. If the company is willing to take you back in California at a later date, that means the job offer is still open for you. In that case, which is mostly a lot of big companies operate in this fashion, then you should still be able to file the 485 using the existing labor certification. Now, obviously there are some companies and some lawyers which are rednecks, that's what I call them. They just don't understand it and they go and they use their own brains and they screw the whole thing up. Then they may say that you require to file another POM. I personally, if I were your company lawyer, I'll ask the company, if this guy comes back to California, are willing to take? And I will ask you, Mayank, are you willing to sign a document that you are willing to come back to California? And that's what some of the company lawyers make them do it. I would, if that happened with you, I would recommend that you go and sign the document. And once you sign the document, you're good, no problem with it. That's what most of the companies do. So that's what I'm expecting your company to do if you're moving remotely right now. There are a lot of people who are expressing that the spending bill or the budget bill might have some provision of not allowing the family-based excess green cards to be coming into the employment-based. At this point of time, we are not giving a very serious thought. There are approximately around 100 different kinds of mini bills that are there that are in the process of getting to the floor of the Congress. We're not giving that much seriousness to this at this point of time. You keep following us and we are going to inform you at a later date when and if that becomes very serious and what actions need to be taken. And we're going to give the drafts of the letters for you at the bottom of the link if it becomes serious. But at this point of time, we definitely want you to contact the Congress people to at least use the existing green cards that we have right now that have been allocated for us.
Ramanuj is kind of asking along the lines of something we discussed earlier. Can he file the I-485 with an employer that he has left a while ago, but the I-140 is not withdrawn with them? And is it mandatory to speak to that employer before filing the I-485? So as we discussed earlier, it is possible to file the I-485 based on an I-140 for a company that you are not currently working for. You may have the intention of returning to that company. But you do need to discuss with that company before you can file the I-485 based on their I-140, because as part of the I-485 application, you're required to submit the I-485J supplement. That is the only form that the company is required to sign as part of the I-485 application package. But that J supplement is crucial. It is the document where the company describes the position that they have open for you, and by signing off on that J supplement, they confirm that the job offer is still there for you. So you do still need the company's involvement. It's not a lot of involvement. It's just one form, no filing fee required with that J supplement, but you do need to discuss with that company in order to get their consent and signature on that.
Rebecca, I have this question. He promised to do it, Sai Kiran, but I need some input from you. This EB1C priority date is April 2021. File an I-140 up. Should they file 485 right now, or should they wait until I-140 is approved?
Yeah, so we discussed a bit earlier that I would file the I-485. It is kind of it will be up to you, of course, and if there is a strong chance that the I-140 is going to be denied, then you may not want to, but if you're really taking a long shot with the EB1C application, then that might be a reason not to. Otherwise, I would probably file the I-485 now.
But do you warn your clients when you file a 485 application for EB1C that, hey, there is a possibility for denial for EB1C? Do you warn your clients?
I mean, if we're filing it, then, we would have reviewed it to consider that it's a strong case. The problem is that with EB1C, it's a very long processing time and there's no premium processing. So you may not find out the results of an EB1C I-140 for a year or so.
Yeah, Sai, it's kind of, your judgment call, as Rebecca is pointing out. She unless, there is something otherwise in the application, though, she's saying that she would definitely file 485 application along with it. Yeah, it is the duty of the lawyer to inform the risks involved in it. And since the risks are only monetary-wise risk, not the status-wise risk, it may be prudent for you to actually file the 485 application. Well, one thing is for sure, though, we all agree that do not use the EAD or advance parole until you have your I-140 approved. Right. Now, that is a completely different stance we take when we file for the downgrade application, or when we file the direct EB2 or EB3 when there is a chance where we can file the I-140 and 485, because typically the denial ratings for EB2 and EB3 are very, very low. And definitely for EB1C, the denial rates are higher. You have to be a little bit cautious, but since it's just monetary and little bit money, some money is involved, not little bit money, I would say good amount of money, but since it's money, I'm going to risk myself with the money, but I don't want to risk myself with the status.
I had seen a question earlier about interfiling the medicals for the I-485 application that's pending. So we do have a template on our website.
Yes, it's there on the link that we provided at the bottom of the video, guys. We have provided a link where you can do the medical interfilings by yourself. Some lawyers are saying they won't recommend. We are recommending. We are not telling that the other lawyers are bad lawyers. It's their opinion. This is our opinion. If you want to use it, we get a lot of people sending emails questioning our authority and all those things. You guys do what you want to. Why are the lawyers telling not to file is that they are thinking that you are risking your money, the $400, $500. Actually, when you go back to the same doctor, though, when you get the fresh medical, so it only costs about $100, $200 extra. We are not worried about that $300 or $500 that you spend, your extra that you spend for the family. We are not worried about, we don't care about that. That's okay to lose. Because if you would get a green card 1 month earlier, and sometimes it may be even 10 years earlier, because sometimes when the date moves back, it won't come back. So we definitely think so that that money is worth to taking the risk. As I was pointing out previously, where the guy was filing the 485, he's risking the money, and of course, filing a 485 is a very heavy risk for EB1C requirements, though. But when it comes to the medicals, though, the financials are not that high. It is a chance that you can take it. Are all the people who filed interfiling were all successful? No, some of them are successful, some of them are not successful. Some of them were being issued a RFE again. If they were being issued an RFE again, we tell them to definitely respond to the RFE by sending the medical against, not relying on what has happened previously.
Avi has an I-485 application that's pending, and he will be getting married soon, and is asking if he can add his wife to the I-485 application. So Avi, you do have to be careful. So you can add a spouse to your application. They can file as a derivative and file their I-485 separately from you, as long as your priority date is still current according to the final action dates chart. So in order for them to be able to submit the I-485 application, first your wife needs to be in the US physically. So if she's not here in the US right now, the first hurdle is probably going to be her getting a visa to come to the US to get a visa appointment at the consulate. If you're in H-1B status, for example, she'll need to apply for the H-4 visa at the consulate once you're married. Hopefully that can be done pretty quickly so that she can come to the US. Once she's here in H-4 status, she can submit the I-485 application if your priority date is current according to the final action dates chart. So if you had filed last October based on chart B, the filing dates chart, and if your date is not yet current according to chart A, she can't file until it is current according to chart A, and if your I-485 is not yet approved at that time.
There's a lot of questions are coming from Venkat Achanta. He already did his promised 3. Srikant Banda, he promised 3 of those things, and a couple of suggestions on with regards to the priority date visa movement, how that works out though. One thing is that if your final action date is current though, don't wait for the RFE according to our recommendation, submit the medicals. If your final action date is current, make sure that your I-140 is approved, do the premium processing. Biometrics, there is nothing you can do about biometrics at this point of time. We're trying an experiment of a trick, which most probably, if that's successful, we're going to release that information next week with regards to the biometrics. But at this point of time, what I want you to do is make sure the premium processing I-140 is approved, you submit the medicals, your final action date is current, then you wait for the biometrics and get your green card approval though. Why are they not approving when the final action date is current, and why are they not issuing RFE? That's exactly why we want you to write a letter to the congressman. You can't contact the congressman for your individual case because it hasn't crossed the normal time which is there, which is taking anywhere between 13 months to 15 months depending on your officer. So you can't raise a service request, you go to congressman, you get a regular response. We want you to write a letter to the congressman describing them, look, it's as a policy matter, they should adjudicate these applications very fast or make it current for everybody so that we will be in adjustment of status. So we would recommend that you take the opportunity and write the letters to the USCIS and write the letter to the congressman. Srini has this question, that since the USCIS has accepted the number of applications, they will not be able to move the dates. No, not right. Not right, Srini. The numbers of green cards will be only allocated at the time when it's been adjudicated, when they give you the green card, not when you file the application. When you file the applications, the numbers are not allocated. Even though Charlie said in his statement that if it is documentarily approvable, number can be allocated at the time, it's a little bit misleading the way he said it, the way it's been interpreted it, because he's a State Department person. The way USCIS works is different. When is it documentarily complete is when an officer looks into it, the final action date is current, the I-140 is approved, the biometrics are done, and the medicals are there. If he checks all those things, he reviews and everything, it looks good, that means it's documentary approval. Once it's documentary approval, he normally takes only about 5 minutes to about 30 minutes to go to a room, not in the same room that we sit in, and they go to a different room and they go to the visa and they pull out the visa number. That's when the visa is actually allocated though, not when we file the application. So Charlie has the authority, if the USCIS does not pull through and adjudicate the applications that are mandatory for them, that are required by the Congress for them to be given to the employment based. If he doesn't do it, then Charlie has an authority to move the dates. Did he ever move the dates like that before? Yes. In 2007, exactly the same scenario. The USCIS were lazy, dumb, they won't move it. He warned them, hey, you better do it. And if they didn't do it in July of 2007, that means somewhere about June 16th of 2007, he made all the priority dates current. Everything, EB2, EB3, everything, he made it current. If you want to check it though, you can go to Visa Bulletin and check those dates though. But it will be a little bit confusion though. What happened was that the priority date moved to current. When the July 1st came in, the USCIS and State Department came up together and said, we are not going to accept any of these applications. Then we have this Congresswoman, Joey Lafrin from San Jose area, and she wrote a very nasty letter to these people. How can you do that? And that letter, somebody, some of our audiences gave a link of that letter in their absolutely stunning letter. And the USCIS and State Department has reversed, and they accepted the application until August 16th of 2016. So those numbers, when you look into the priority dates, are really confusing. But I want you to go check it out for the history in 2007. It's in the same Visa Bulletin. Go back to 2007. You would be able to see what happened at that point of time. Most of you guys may not be in this country, may be too young at that point of time, but I've been in practice for a long period of time by that time. I have seen that happen, so I'm expecting the same thing. If you keep writing, our videos are watched approximately around 50,000 people. If you write the letters to them, if each of you guys write one letter and have one of your friends, that's 100,000. Last month, according to their statement, they only received 450 emails. And this time, if just you guys are going to send email, the link of the email, what to send, the content of it, everything is provided for you by my business partner, Emily Neumann. In her blog, it's given at the link at the bottom of this video. If 50,000 people are watching this video in different sources, if at least good number of people will do it, that's going to act, and the Congress will probably proceed it. There is a group of people that are trying to make an appointment, or they already said that they made an appointment with Congressman Joey Lafrin. I'm going to update you about that meeting. If any of you guys are in San Jose, San Francisco, and that area though, you may want to join that group representing yourself and going to Joey Lafrin's office. If you go as a group, it definitely makes a big impact. She is the goddess for the employment-based immigration. We want you guys to approach her and let her know what the problem is so that things can get much better.
Amit is asking a good question about the downgrade process for I-140s. Is the employer required to pay the fees associated with that I-140 downgrade, or can it be paid by the employee? So for the I-140 petition, the fees can be paid by the employer or the employee. It's not legally required to be paid by the employer. So in the three-step green card process, the employer is legally required to handle all the fees related to the perm process. But at the I-140 stage, it could be handled by the employer or the employee. So if you are discussing with your company, they're kind of hesitant about filing this downgrade application because it's essentially a second I-140 petition where they may have already filed and paid for your EB2 I-140, you can offer, if they are willing to file it and sign off on it, the fees can be handled personally by the employee. That $700 DHS filing fee and any legal fees associated with the I-140 can be handled by the employee. So actually there is not that much obligation required from the employer in filing a downgrade. We have, I believe, a couple other videos in our YouTube channel that explain sort of the mechanics of the downgrade, what the responsibility of the employer is. If they have already signed off on an EB2 I-140, they are not telling the government anything different when they sign an EB3 I-140 for you based on the same perm. They're stating that it's the same job requirements, that you have the same qualifications. It's just another application in a separate category, and they may need to provide a few more years of tax returns, but besides that, if you're willing to handle the fees, then the obligation on the employer is actually not very much.
Question comes in that the premium processing has been pending for 8 weeks. The lawyers are hesitant in raising a service request. Any suggestions? Oh, there is a technical problem, Mr. Manu Singh from YouTube, is that especially if you have a SRC number, when we are raising the service request, they're telling that it's within the processing time. Even though online it says 8 months, they normally we'll have to wait extra 2 months to raise a service request though. That's the reason why, if it's a Texas Service Center though, if you are filed in the October month, they are not allowing to raise a service request. Most probably we will be able to do it in about a month or two, we will be able to do it. Balu has this question, can we use the same labor and perm to file an I-140 for EB2 and EB3? Absolutely, that's what we've been doing all along. That's what we did. A lot of people in October, their I-140 was already approved. Yes, you can use the same labor. If it is qualified for EB2, it is qualified for EB3. It's just like what Emily has one time pointed out, all billionaires are millionaires. That means that all EB2s are EB3s, but not all millionaires are billionaires. So if you document it in the labor certification for EB3, you may not be able to use it for EB2, but vice versa, you can.
Monte is asking if someone in H-1B status, if their priority date becomes current in October, can they file the I-485 if their family, if the spouse and children are stuck in India with a 221G waiting for the H-4 visa? So yeah, that is kind of the situation that we've been discussing a bit today. In that situation, you can, Monty, file the I-485 on your own and then later include your family in the I-485 application when they are able to come here in H-4 status, which hopefully won't take too much longer. But in that situation, it is up to you, but we would probably recommend that you go ahead and file the I-485 for yourself to kind of get that submitted and locked in. And then, like we said earlier, once your family has come to the US, as long as your priority date is current according to the final action dates chart, once that happens, they can file their own I-485 applications based on your pending I-485. The thing is, they just need to be able to do that, get to the US and file those before your I-485 gets approved.
Mukherjee from YouTube has this question. His priority date is December 2013 EB2. His company doesn't want to downgrade it. He is about to get a permanent residency in another country and he has to visit by June 2022. Should I wait to move or to the new country? That's a tough question. There is a chance that EB2 also might move until December 2013. Especially if the State Department acts properly, it should be able to move. Since you have until June 2022, we will be able to find out by April of 2022 to see if it's going to move to December 2013. One other thing is that I don't know, a lot of people who get a PR in Canada, they go there and get it and come back into the United States again and work on H-1B and then later on make a move if they want to. So if that's the way that you want to go, you can always go there and come back and stay here and try to see how it goes on. And if it still does not turn around, then probably you can move to Canada if you want to. I mean, if it's Canada is your target, though. You may ask a question, if you don't have a passport stamping, can you still go to Canada and come back? There is a provision that allows that if you are staying there for less than 30 days and coming back into the United States, it is allowed for you to come back into the United States on H-1B or H-4 without getting stamped. And yeah, you can come back without getting stamped, and come back into the United States. It's called automatic revalidation. There's an article that we have written. It's there on RN Law Group. You can search that thing. Yeah, go ahead. Sorry.
Leah is asking, does the travel ban apply if you are using the advanced parole card? So it does not. If you have a valid advanced parole card in hand already, the travel ban, the presidential proclamation does not apply to you. You don't even need to contact the consulate to get an NIE or anything like that. You can travel directly from India to the US without the 14 days stopover in another country.
Amar has this question. My birth certificate has my mom's pet name. Pet name is the name that normally people call, like Munno, Chinno kind of things, and Nani kind of things, Sweetie, Preeti, or something like that. And there is no documentation. Will it affect the 485? I would do one thing, get 2 affidavits from the relatives who know your mom, and when they write the affidavits, they can write your mom's name. Let's say your mom's name is Sujata, also called as Munni. I'm just making a name there. In that way that you're covered, because these people who are aware that your mom's pet name and her real name and your date of birth, they can write an affidavit. That should be sufficient enough for you right now to file the 485.
Human is asking about the potential timeline for the I-751 removal of conditions application. His biometrics have already been taken. So this has been a big problem for the past few years. Under the previous administration, the I-751 processing times have gotten crazily long, unreasonably long, and USCIS under the new administration has recently stated that that is one of their priorities, to get the backlog of the I-751 applications eliminated so that it's back to a more reasonable processing time. However, they are still working on that backlog. I would expect it will still take several months for them to work through that. I've been telling some of our clients who we've filed 751s for to expect 8 to 12 months for it to be pending. As long as you have that I-751 receipt notice, that is proof that it's pending. Even if your conditional card expires, you are authorized to remain in the U.S. and continue working. The problem is international travel. Of course, you may need to get an I-551 stamp in your passport if the I-751 is still pending, which can be difficult depending on your local USCIS field office. So if you can avoid international travel until that's approved, we would recommend it. But otherwise, just sit tight and hope for the best.
Raja from Facebook has this question. He did all 3 activities, but I'm confused his question. But I-140 is for 2 years only, so I don't know what the I-140 is for 2 years. I'm trying to give preference to 3 people that did all the activity wrote in the letter, but I couldn't understand your question. What do you mean I-140 is for 2 years? I-140 doesn't have an expiration date at all. It just says when it is approved, so I'm really confused about that question. If you rephrase it, I will try to answer. Sheba, she promised to do the activities, write letters to the Congressmen. Thank you for it. Your priority date is 2016. EB2, shall I leave the full-time employment, go back to the old company, or can I stay with the company and file the downgrade application? It depends on what your company that has the I-140 approval in EB2 wants you to do. If they are okay for you to stick with where you're working at and they're willing to file the downgrade application, assuming that they feel they have the ability to pay, yeah, you can stick with where you are, and the old company can still file the downgrade application and then still file the 485 application. And Sheba, I would do one thing. I mean, I would not wait until October. I will prepare the application application right now itself. And even our office offers, if you want to, contact at info@rnlawgroup.com. We give you the details at the bottom, is that you can file the downgrade application right now, even though the priority date is not current, and probably convert into premium processing and get the decision so that you are ready when it comes to the October of 2021, you're ready. So you may, depending on the company, if the company wants you to go back, 2016, I'm going to go back to if I were you. There are people who are asking questions about, there's one other 3P question that was there, is that if the priority date, 3 promises that he did, if the priority date does become current in October, and if he misses the boat, how long it's going to take for the person to get into the 485 application? I can't tell. Last time they waited until December and they moved the dates back in January for certain things, and February for all other things. There are some times where people have waited, especially in 2012, it was May 1st of 2010, and people missed the boat. It took them 9 years for the boat to arrive back. So that's the reason why we are recommending people to prepare your application, get everything ready, file it. Does it happen the same way last year, where the priority dates were current in October, November, December, and in January they backlogged only for EB3 people to 1 year extent though. And in February, of course, everything went back. Does it happen every time the same way? No, not true. Sometimes they may only give 1 month. So you may want to prepare yourself and get ready to file right now, rather than wait until October.
We've seen a couple questions about what it means if your I-485 shows that it's at the field office. So we know that the I-485 applications, some are being distributed to local USCIS field offices for the final adjudication. We've gotten some RFEs from local field offices asking for the medical exams, for example, after the priority date has become current for the pending I-485. Not always, though. So sometimes the applications are just being approved directly at one of the service centers or at the National Visa Center. It does seem like USCIS is kind of sending the applications, the pending I-485s, to between different service centers, including some different field offices, possibly in an attempt to speed up the processing and get more of them approved as soon as possible. So if your case is at a field office, that hopefully means it is close to getting approved if your final action date is current. Before last year, when interviews were still required, in-person interviews were required, I-485s always went to the local field office that had jurisdiction over your residence because you needed to be called in for an in-person interview. We haven't been seeing the in-person interviews being required for most employment-based cases this past year during the pandemic, so it looks like that trend will continue. So it doesn't mean that you'll necessarily be called in for an interview if your case is at the field office. It may just mean that it's getting close to being approved. Maybe they're sending it to a field office to send RFEs for missing medical exams or missing documents.
Questions with regards to the going to the old company comes frequently, guys. Especially when the priority date is getting current and you don't have the existing labor certification approval. I would want you guys to open the discussion with your old employers to see at what extent they are. Are they willing to help you out to file the 485 application? Are they willing to downgrade it right now? Do they have the condition of you joining the company? It's better to open the discussion right now rather than move to the September to have the discussion. Because come September, they will be busy, immigration lawyers will be busy. So it's always good to open the discussion right now rather than discussing at a later date. Questions are coming with regards to, in October, visa bulletin, will it be a date of filing or the final action date? we got the very clear indication from the State Department that they're expecting USCIS to honor the date of filing in October of 2021.
Filing or filing?
Date of filing.
Yeah.
Anything else, Rebecca?
I guess Divya had a quick question about working for a Canadian company while she's in the U.S. on an H-4 visa. So even if the company is not located in the U.S., if you are physically in the U.S., you need work authorization in order to be employed while you're physically within the U.S. So you cannot work for a Canadian company remotely while in the U.S. unless you have an EAD card while in H-4 status.
Niharika has this, she did 3 activities, so I want to give. Can you provide medicals when pregnant? The answer, I think so, according to the medicals, according to doctors, no. It's better that you do provide the medicals after you're delivered. If by any chance you get an RFE, you can write a letter to them, look, I'm pregnant, I can't provide those things. You can write it to them. They'll postpone it. They may ask, if you're not the primary applicant, they may approve your spouse's application, and they may wait. If you're the main applicant, they will not approve either of those people's application. But no, there are some shots that need to be taken. Based on our history, what we observe with the doctors, they do not administer those things when people are pregnant. Anything else?
No, I don't think so.
Thank you guys for coming in. Don't forget that we have provided the links for you to write the Congressmen. And if you want to contact us for pre-preparing the application, you can send an email to info@rnlawgroup.com, where we can prepare your 485 or even file I-140 downgrade application. We don't want to wait until October to make a decision. We want you to do active right now rather than waiting until October. Thank you guys for tuning in. Wait for next week for any updates.